If there's any detainers or anything, I'll sign those. Other than that, no, that's fine. This minute, Mr. Matthews, I'm duty judge today, so I'm going to set this back here and keep my fingers crossed if that rings in my fingers. Yes, sir.
Yes, Your Honor.
Any idea how many we have?
We have 5, Your Honor.
Thanks, you guys. No, but no other. One second. Yeah, give me one second, I'll pull all those.
Thank you, Your Honor.
Lopez. How long has she been sitting in the co-pilot chair? I guess Mr. Matthews has told you what first appearance is, what it involves. I'm not deciding what charges are, that's his job. You know, all I'm doing is determining whether there's probable cause to hold them. And if I was to release them, that doesn't mean the state doesn't charge them. The state still gets the final say-so. I'm just determining where they're going to spend the night tonight, or how much money it's going to cost them to do it. And you got me unmuted. All right, good afternoon, everybody. Judge Stamey here in the Polk County Courthouse. If you would, you guys don't have to stand up, but where you are, just raise your right hand to be sworn in.
Derecha.
All right, I see your right hand's raised. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? If you agree, say I do.
I do.
Great. Everybody that said I do, put your hand down. If you didn't say I do, raise it real high, and I'll be able to identify you as not being sworn in. All right, I think everybody's hands is down. As far as our interpreter, who do we have today as our interpreter?
Good afternoon, Judge. Elias Lopez, Staff Court Interpreter present.
Mr. Lopez, we have 5. If you don't mind, Mr. Cohen wants to, he's my only private attorney. I'm going to get him out first, and then we'll do the 5.
Thank you, Your Honor. Your Honor, Lee Cohen for Antonio Lopez. Mr. Lopez, can you please approach the podium?
Señor Antonio López, acérquese al podio, por favor.
And does he need a...
He doesn't need an interpreter.
All right, so he's not one of our 5, Mr. Lopez.
He's not, sir?
He doesn't need a Spanish interpreter.
Yes, thank you.
You got it. Mr. Antonio Lopez, you're here for 4 charges. You're here based upon a capias that was issued when you failed to appear for a pretrial out on the Northeast Branch Office with Judge Cole. The charges are reckless driving, leaving the scene of an accident without leaving what the law requires for information, possession of marijuana known as cannabis, and possession of drug paraphernalia. Mr. Cohen, are you going to be representing him on these 4 charges?
Yes, Your Honor, I have been representing him during the time that the case was in Lake Alfred and now. And the case numbers are 26MM290, 26CT234, 26CT231. The case has been assigned to cities in Bartow now to M5, and very coincidentally, M5 is doing arraignments this week. I talked to the clerk about the availability of sending him for Friday morning for M5 arraignments, and there's already an offer in the case, and so we may be executing the offer on Friday morning.
You know, he missed pretrial, so normally I would want to put him back at pretrial, but if you want to designate it as a pretrial, but just put it on like for 8/29 at the beginning of Judge Kaler's docket.
That would be wonderful, Your Honor.
I don't think she'll mind too much, especially with a no bond. Kind of almost treat it like a 5-day hearing, if you will, you know, because it's... All right. So, sir, Mr. Cohen's representing you. I've looked over each of the... There's 4 capias for the 4 charges. I looked over each 4, finding probable cause. Judge Cole wanted you held no bond. So we're going to hold you no bond. But as Mr. Cohen said, the good news is you have court real quick in front of the judge assigned to you down here in Bartow. So we'll set you over for a pretrial. We'll put it at 8/29 with the M5 arraignment, jail arraignments on Friday.
Thank you, Your Honor.
You bet.
And if I just may, Mr. Lopez, I'm going to try and schedule a jail appointment with you for tomorrow. Actually, today's Wednesday. Just think about that for a second. Thursday afternoon to talk about your cases.
All right, that's fine.
Thank you, Your Honor.
Good evening, Mr. Cohen.
Thank you, Your Honor.
Mr. Lopez, I'm going to read the advisory in English. When I'm done, could you please read it in Spanish?
Yes, Your Honor.
Good afternoon, everyone. This is your first appearance hearing. A first appearance hearing has 4 purposes and 4 purposes only. First, I will advise you of the charge or charges that have been filed against you. Second, I will ask you if you have an attorney representing you. If you have hired counsel and they are present, they will speak on your behalf. If your attorney is not present, you will have the option of proceeding forward with your hearing today or postponing your hearing until tomorrow. If you postpone the hearing, it is your responsibility to contact your attorney to let them know you will have court tomorrow. If you wish to move forward without your attorney present, we can do that. If you do not have an attorney, I will ask if you can afford one. If you can't afford one, we will make that note and then move on with your hearing. If you cannot afford one, and if you qualify, I can provisionally appoint the office of the public defender to represent you, pending you filling out an application. You have a right to have your attorney present before and during any questioning. Third, if there are any challenges to probable cause, I will address those challenges. And finally, I will review your bond or bonds and any other release conditions with you to determine if any changes are necessary. Please be aware, if this court places you on pretrial release today, regardless of whether it is straight pretrial release or a condition of your bond, the conditions announced in court today go into effect immediately, meaning even while you remain in custody. For example, if you were told to have no contact with a certain person, let's just say the alleged victim, and you call that person from the jail before you are released, you are in violation of your pretrial release conditions. Throughout this entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located at the courthouse, as well as where you are located at the jail, is being recorded. There is an assistant state attorney present, listening to everything that is being said, and also everything is being recorded. So do not say anything about the crime itself. Please keep these rights in mind as we go through the process. Please step forward as your name is called.
Buenas tardes a todos. Esto es su audiencia de primera comparecencia. La audiencia de primera comparecencia tiene solamente 4 propósitos. Primero, le informaré sobre el cargo o los cargos que se han presentado en su contra. Segundo, le preguntaré si ya le está representando un abogado. Si ya usted ha contratado abogado y este se encuentra presente, entonces será el abogado quien hable en representación suya. Si su abogado no se encuentra presente, usted tendrá la opción de proceder con su audiencia de hoy o posponerla hasta mañana. Si usted decide posponerla, será su
Mr. Elias, could you unmute yourself, please?
I'm sorry, Your Honor. I'm starting over. Thank you.
Yeah, Mr. Lopez, we apologize. We had someone making noise, so we attempted to mute them and muted you by mistake.
Yes, sir. Thank you. Primero, le informaré sobre el cargo o los cargos que se han presentado en su contra. Segundo, le preguntaré si ya le está representando un abogado. Si usted ha contratado abogado y este se encuentra presente, entonces será el abogado quien hable en representación suya. Si su abogado no se encuentra presente, usted tendrá la opción de proceder con su audiencia de hoy o posponerla hasta mañana. Si usted decide posponerla, será Si usted decide posponer su audiencia, será su responsabilidad contactar a su abogado para hacerle saber que tendrá una audiencia. Nadie más hará esto por usted. Si usted desea proceder sin que su abogado esté Si usted desea proceder sin que su abogado esté presente, puede hacerlo. Si usted no tiene abogado, le preguntaré si puede pagar uno. Si usted puede, tomaremos nota de esto y procederemos. Si no puede y califica, el juez asignaría provisionalmente la oficina del abogado de oficio para que le represente en espera de que usted llene una solicitud para estos servicios. Usted tiene derecho a que un abogado esté presente antes y durante cualquier interrogatorio. Tercero, si hay alguna objeción en cuanto a motivo fundado, estas se abordarán inmediatamente. Finalmente, voy a estar revisando sus fianzas y otras condiciones de liberación con usted para determinar si es necesaria cualquier modificación. Debe saber que si el juez lo pone hoy bajo condiciones de libertad condicional, independientemente de si es directamente o como condición de su fianza, las condiciones que se anuncien hoy en esta audiencia entrarán en efecto inmediatamente, aunque usted se encuentre aún encarcelado. Por ejemplo, si se le ordena no tener contacto con determinada persona y usted llama a esta persona desde la cárcel antes de salir en libertad, usted entonces estaría violando su libertad condicional. Durante todo este proceso, usted tiene el derecho constitucional de permanecer en silencio. Si usted decide no permanecer en silencio, todo lo que diga podrá ser usado en su contra. Todo lo que se diga donde yo me encuentro, así como también donde usted se encuentra, está siendo grabado. Hay un abogado de la Fiscalía presente escuchando todo lo que se dice, así que no diga nada usted sobre el delito en sí. Por favor, tenga presente estos derechos durante el transcurso de este procedimiento y pase al frente cuando se llame su nombre. Gracias.
Thank you. First up, we have Yanni Armas. Mr. Armas, you're charged with driving while your license is suspended with knowledge.
Señor Armas, usted ha sido acusado con manejar mientras su licencia estaba suspendida con conocimiento de esto.
Sir, are you going to hire a lawyer that you choose, or do you want me to appoint the public defender?
Señor, ¿usted va a contratar un abogado que usted elija o quiere que se le asigne el abogado público?
No, asignado.
Como dijo,
Abogado asignado.
public defender.
I'll provisionally appoint that office to represent you.
Voy a asignarle provisionalmente esta oficina para que le represente.
I reviewed the sheriff's affidavit and I find probable cause for the charge.
He revisado el affidavit del alguacil. Encuentro que hay motivo fundado para el cargo.
It looks like you do not have any ties to Polk County, and you have 5 open criminal cases in Hillsborough County.
Al parecer, usted no tiene ningún tipo de vínculo con el condado Polk y tiene 5 casos penales abiertos en el condado Hillsborough.
I believe enhanced bond is appropriate.
Creo entonces que una fianza incrementada es apropiada en su caso.
I'm going to set your bond at $2,000 cash or surety, $2,000.
Voy a establecer su fianza en $2,000, efectivo o garante.
Step to your left, please.
Pasa a su izquierda, por favor.
Next up, we have Karen Cordova.
Karen Córdoba.
Halifax.
Sí.
Yes.
Ma'am, you're charged with operating a motor vehicle without a driver's license.
Señora, usted se le ha acusado con manejar un vehículo automotor sin tener una licencia válida de conducir.
Are you wanting to hire a lawyer that you choose, or do you want me to appoint the public defender?
¿Va a querer usted contratar un abogado que usted elija o quiere usted el abogado público?
El abogado público.
Public defender.
I'll provisionally appoint that office.
Se le asigna provisionalmente esta oficina.
I find probable cause based upon the affidavit in your case.
Encuentro que hay motivo fundado para el cargo basándome en el affidavit en su caso.
Pretro has determined there is no ICE hold on her as we speak. Does the clerk's office believe there's an ICE hold? Let me.
No, it's just a charge for unauthorized.
Yeah,
I had just a moment ago.
yeah. And I thought that as well, but they charge her with an M2. So they looked like they were going to enhance it, but they did. Ma'am, we're just looking to see if ICE has placed a hold on you.
Señora, estamos mirando a ver si ICE ha puesto una orden de retención sobre usted.
The police officer in his affidavit indicated that that would happen, but we do not show any proof that that has happened.
El oficial de policía en su affidavit indicó que eso sucedería, pero no hemos visto prueba alguna de que eso haya sucedido.
Judge, I don't have any detainer documentation.
All right, ma'am, it doesn't look like there is an ICE hold. Your bond will be set at $1,000. Have a nice day.
Bien, señora, al parecer no hay una orden de retención de ICE en su caso. Su fianza se va a establecer en $1,000. Tenga buen día.
Jeffrey Del Rosario? Sir, you're charged with domestic violence battery. Are you wanting me to appoint the public defender?
Señora, usted se le acusa con violencia intrafamiliar, agresión física. ¿Quiere usted que se le asigne el abogado público en su caso?
Sí.
Yes.
I'll provisionally appoint that office to represent you.
Voy a asignar provisionalmente esta oficina para que le represente.
After reviewing your affidavit, I find there's probable cause.
Después de revisar el affidavit, encuentro que hay motivo fundado para el cargo.
Do you show any prior history for this gentleman? Sir, having found probable cause, I'm going to set your bond at $5,000 cash or surety.
Bien, habiendo encontrado motivo fundado, voy a establecer su fianza en $5,000, efectivo o garante.
I'm going to make that bond a condition of pretrial release.
Y voy a hacer esa fianza una de las condiciones de su libertad condicional.
So if you post that bond, you must immediately check in with the Office of Pretrial Services here in Bartow.
Así que si usted deposita esta fianza, debe inmediatamente reportarse con la Oficina de los Servicios de Libertad Condicional aquí en Bartow.
Sign up with them in person and call them once a week while your case is pending on Tuesdays.
Entonces, debe reportarse con ellos en persona y después de esto, llamarles una vez por semana los días martes mientras su caso esté pendiente.
You have all the standard conditions plus the following special conditions.
Va a tener usted todas las condiciones estándar de libertad condicional, además de las siguientes condiciones especiales.
While on pretrial release, you're not allowed to be in possession of weapons, firearms, or ammunition.
Mientras esté bajo condiciones de libertad condicional, no se le permite estar en posesión de armas, armas de fuego o municiones.
You're not allowed to have any intentional contact with the listed victim.
No tendrá permitido tener ningún contacto intencional con la supuesta víctima en el caso.
That means directly, indirectly, or through a third person.
Y esto significa directa, indirectamente o a través de terceras personas.
You must stay 500 feet away from her home, her vehicles, where she works or where she goes to school.
Debe usted mantenerse alejado al menos 500 pies de ella, el hogar de ella, su vehículo, lugar donde ella trabaja o va a la escuela, si es el caso.
Step to your left, sir.
Pasa a su izquierda, señor.
Next up is Jose Ramon Diaz Torres.
José Ramón Díaz Torres.
Sir, you're charged with failing to appear for court on a charge of driving while your license is suspended with knowledge.
Señor, usted ha sido acusado con no comparecer en corte y esto por un cargo de manejar mientras su licencia estaba suspendida con conocimiento de esto.
Do you want me to appoint the public defender to represent you?
¿Quiere que le asigne el abogado público para que le represente?
Sí.
Yes.
I'll provisionally appoint that office.
Voy a asignar provisionalmente esta oficina en su caso.
I'm looking at the warrant issued by Judge Kaler.
Estoy mirando ahora mismo la orden de detención dictada por la jueza Kaler.
There is probable cause that she set your bond at $1,000.
Encuentro que hay motivo fundado. Ella ya estableció su fianza en $1,000.
Have a nice day, sir.
Tenga buen día, señor.
And I think we're up to Achille Cruz Reyes.
Señor Aciel Cruz Reyes.
Sir, you're charged with operating a motor vehicle without a valid driver's license.
Señor, usted ha sido acusado con manejar un vehículo sin tener una licencia válida de conducir.
Do you want me to appoint the public defender to represent you?
¿Quiere que se le asigne el abogado público para que le represente?
Sí.
Yes.
I'll provisionally appoint that office.
Voy a asignar provisionalmente esta oficina.
I've read the trooper's affidavit.
He leído el affidavit del trooper en su caso.
I find probable cause for the charge, and I'll set your bond at $1,000.
Encuentro motivo fundado para el cargo. Voy a fijar su fianza en $1,000.
Sir, you do have a hold for ICE.
Señor, usted tiene una orden de retención de ICE.
So I'm going to ask the clerks to prepare a immigration detainer for my signature.
Así que voy a pedirle a la Secretaría Judicial que prepare un documento de detención de inmigración para mi firma.
Have a nice day, sir.
Tenga buen día, señor.
Mr. Lopez, would you like to make an announcement, please?
Yes, señor. ¿Alguien más para asistencia en español? Levante la mano ahora, por favor. I see no hands raised here. Maybe excused.
You bet. Have a great day, sir. Thank you for your help.
Thank you, innocent you.
All right, everybody, we're going to start picking up the pace a little bit. The Spanish always slows us down a little bit for obvious reasons. Everything has to be said twice. Just like my little speech told you, there's 4 things I do today. tell you what you're charged with, what's holding you, just in case you didn't already know. 2, I talk to you about a lawyer. If you want the public defender, I'll provisionally appoint them, and my logic is you're not making any money if you're in jail, and unless I'm the one that releases you, I don't know how long you'll be in jail. So I'll provisionally appoint the public defender, but what that means is you're going to have to go fill out an application at some point in the future to make sure you qualify, because some people don't. They make too much money or they have too many assets. And public defender is meant for indigent representation. The third thing I do is I determine probable cause, and just like the ones I've already called up, I've read everybody's affidavit back in my office just before lunch and over the lunch hour, so I have a good idea of what I believe probable cause is or is not in each case. But I'll certainly give the attorneys a chance to argue and convince me of their positions. And lastly, I set a bond. We have standard bonds in Polk County, meaning misdemeanors are lower than felonies. Violent felonies are higher than non-violent felonies. But I will look at, to my left, the screen here shows me whether or not you have a lengthy criminal history, whether or not you have a history of failing to appear, and whether or not you have any ties to this area. Bond is not meant to punish you. Bond is meant to make sure you come to court. But if you have a history of not coming to court, or you live in Montana, I'm going to treat that differently than someone that has born in Polk County, always lived in Polk County, everybody that knows in Polk County, and you've never lived anywhere else. You might be less of a risk of not coming back to court than someone that's just passing through an I-4 and has no ties to Polk County. All right, real quick, everything's being recorded. A lot of times people want to come up and try to say, hey, Judge, I didn't do this. Let me out of jail. Just know this, my job's not to determine if you did or didn't do the crime. That's what trials are for. You guys are entitled to trials. If I was someone who witnessed what happened, then I couldn't be the judge, I'd be a witness. You can't be both. So I don't know if you did or didn't commit the crime. My job is to determine from the 4 corners of this document if the police have sufficiently alleged all the elements of a crime to satisfy the requirement of probable cause. Just so you know, what's needed to hold you as probable cause, that's a low standard. What's needed to convict you at trial is a high standard, beyond and to the exclusion of every reasonable doubt. So today, again, me read the document, determine if the low standard's been met, not what's needed to convict you at trial. A lot of times people want to say, hey, Judge, can I tell you something? You really shouldn't talk. Everything's being recorded. Sometimes people try to convince me that they didn't do it. And again, that's not what today is for. But in your desire to convince me you didn't do it, you say things that could be used against you. How ironic would that be? You said something in first appearance to me that the state attorney, that's the first piece of evidence they play to the jury when they're trying to convict you with this high standard. The first piece of evidence they give the jury is you admitting to something that otherwise might not have been proved, but for you saying it here in first appearances. So I'm not trying to be rude. You just really shouldn't be doing a whole lot of talking. Today is for those 4 things only. We're going to do the gentlemen at South County first, and the ladies at Central, and finish up with the men in back. To that end, let's go with Cesar Batalis. Mr. Batalis, you're charged with trespass.
Yeah.
You want me to appoint the public defender?
Sure.
I'll go ahead and appoint the public defender to represent you. Sir, I've looked over the affidavit from the sheriff. I find probable cause. Ms. Smith, you want to be heard as it relates to bonds?
Yes, Your Honor. I was going to ask for him to be released on his own recognizance since his trespass is a nonviolent crime. I would point out he was just found incompetent to proceed on 26 MM002033BA on May 23rd. Our office already represents him on that charge, and I believe that was another trespass, so I'd ask for him to release on his own recognizance on this charge.
Mr. Matthews, anything from the state?
State's opposed.
Mr. Vitalis, I find probable cause. This is a M1. I'm going to set your bond at $1,000. Have a great day, sir.
And we were.
Okay.
Yeah.
Hey, can I go back to my
Mr.
talk?
Cox, jump on up there, yeah.
I have Ashley Lancaster on the docket, Judge. She's got a case number, I think it's an old case, CF-23-9971 is what I had.
So the docket for C-2647.
There's a new charge out, Judge.
Yeah. Miss Ashley Lancaster is here having been charged with grand theft and dealing in stolen property. Mr. Cox, are you going to be representing her on this matter?
I am, Judge.
Okay. So we're on to the third step. I have a warrant Ms. Lancaster, that was already, the affidavit was already previously reviewed by Judge Denmark. She did that on May the 13th after she reviewed your affidavit. She determined that there was probable cause, and she signed off on a warrant that led to your arrest. Mr. Cox, would you like to be heard as it relates to bonds?
Judge, it apparently it's set 5,000 on the first count. I would ask for the same on the second count. I know it's an F2, but I would ask for the same.
5,000 for the grand theft is standard bond. Mr. Matthews, your thoughts on the F2 dealing in stolen property?
Judge, as I know the court is aware, there's not a standard bond for an F2, but I think the typical bond is $15,000.
I think he's completely wrong, Judge. I'm pretty sure it's 5,000.
Real curious, that she has an open case, but this, I gather, is not a Parker situation. There was an open bond case on 26 CT 2557. So when did she, I was a little bit confused about,
It appears
The
that
timing
this
of the
case
call.
occurred on, according to the affidavit that I have.
so on that case, on the previous case that she's out on bond, when did she go out on bond and or pretrial release?
I don't know, Judge.
So she's been out on bond on another case since March of 26.
May.
November of
I
25.
know, so what I'm looking at, it shows the affidavit on May of 26. Date of incident, May 12 of 26. Now, undersigned affiant swears that reasonable grounds to believe that on 11/28 of 25 in Lake Wells. So that's a little bit, I don't know if that's a typo, Mr. Matthews, or if there's some kind of inability to pinpoint when the theft took place, alleged theft. But on 5/8, the alleged victim reported the theft of the property. So I gather that's why pretrial hasn't highlighted that they believe that this is a Parkerable offense, because the allegations, at least according to the face of the affidavit, says November of 25. But that's the only place I see that date. So that, assuming that's not a typo, that gives me some concern that this is not a Parkerable offense.
I don't have enough to dispute that at this time. Of course, that's the kind of thing that can be brought up later once there's more information in front of us.
I'm not saying anything, Judge.
All right, I'm going to set your bond at, I'm going to set the bond on the dealing and stolen at $15,000, so it's $20,000 total. We're going to make these two bonds conditions of pretrial release. So if you're able to post those bonds, you must immediately check in with pretrial services here in Bartow. Sign up in person, calling them on Tuesdays and Thursdays. You have all the standard conditions, plus Judge Denmark has got you some special conditions she wants you to adhere to. She wants you to do condition 17, which is you're not allowed to have any intentional contact with the listed victims. Stay 500 feet away from them, their home, their vehicles, where they work, or where they go to school. And you can't have contact directly, indirectly, or through a third party.
Yes, sir.
All right. Have a nice day. Good to see you, Mr. Cox. All right, back to the gentleman in South County. We are up to Christopher Coyne. Mr. Coyne, you're charged with, looks like you're in the Polk County Jail. While you're in the Polk County Jail, they've charged you with criminal mischief and preventing, hindering a firefighter or emergency equipment to function. Long and short, they've accused you of basically damaging a sprinkler in the jail cell that caused it not to be able to be operable, and it damaged the equipment. Sir, do you want me to appoint the public defender to represent you?
I have a lawyer and I would like the opportunity to contact him and return tomorrow.
So who's your lawyer? You're saying on another case? Because we don't
Yes.
have anybody that's been, I know you have an open case. You're
I didn't know
clearly
that,
in jail.
I was not aware of this case, so I'm just finding out about it now.
Okay. So who's your attorney that you've hired for this case?
Tom Grayjack will be representing me.
Okay, so you haven't hired him yet, so you want to come back tomorrow with a chance to call Mr. Grayjack and have him come in to represent you tomorrow?
Yes, sir.
Okay, Mr. Matthews, seems like a fair request.
And he's allowed to do that, Judge.
All right, Mr. Coyne, we'll see you tomorrow, sir.
Thanks.
Have a nice day.
Thank you.
Lamarcus Davis? Mr. Davis, you're here. Mr. Davis, you're here on a similar situation. While being an inmate in the South County Jail, you've been accused of the charges of resisting an officer without violence, resisting an officer with violence, and battery on a police officer. Do you want me to appoint the public defender on these 3 new charges?
No.
Did you,
No more
did I
charges,
hear you
sir.
right?
No
You
more
said no?
charges. No more charges, sir. Okay, no more charges.
Did y'all make out what he's saying?
He said no more, I can't hear him.
No more charges, sir.
He doesn't think he has charges.
You do, you have these 3 charges. So bottom line, do you want the public defender, yes or no?
No.
All right, if you change your mind, you can always ask later. Sir, I've looked over your affidavit, I've read it in its entirety. I find probable cause for these 3 charges. I'm going to set your bond on the resisting without, that's a misdemeanor. I'm going to set your bond at $2,500. I'm going to set your bond at $7,500 for the resisting with. And I'm going to set your bond at $5,000 for the battery on a law enforcement officer. Now, it looks like he was on pretrial release while he was on 26 CF 1466. What are the charges on him?
Battery or resisting with violence.
So he's in jail for alleged crimes of battery on a law enforcement officer and resisting with violence. The judge at first appearance put him on pretrial release. He hasn't bonded out yet, but while in jail, he's picked up those same charges and a new one.
Those are the allegations, yes, sir.
All right. Sir, I'm going to revoke your pretrial release on the earlier case. I'm going to hold you no bond pursuant to the authority of Parker versus State. Do you want me to appoint the public defender on the old charges that you're now being held no bond on?
Yes, Daniel Hernandez.
Okay, yes, Mr. Hernandez. So, sir, now that you know that I'm holding you no bond on the old charges, have you changed your mind? Do you want the public defender on the new ones? I'll take that as a no. All right, sir, have a great day. Next up, we have Trayvon Jefferson.
Last be heard on this one, Judge.
Mr. Jefferson, you are charged with armed burglary of a dwelling, structure, or conveyance, and grand theft of a firearm, as well as grand theft. So 3 total charges, a first-degree felony and 2 third-degree felonies. Do you want me to appoint the public defender?
Yes.
I'll provisionally appoint that office. Sir, I've looked over a warrant that was already previously signed by Judge Hill about 3 days ago. From this, I find probable cause, just as he did after reading your affidavit. Mr. Matthews, you want to be heard as it relates to bonds?
Yes, Your Honor, with relation to the armed burglary of a dwelling, that was alleged to be of a dwelling, so it is a qualifying offense as an enumerated dangerous offense. It is also a first-degree felony punishable by up to life. The defendant is not entitled to a bond on those charges. The state is asking the court to hold the accused no bond based on that charge. If the court is not so inclined, I will request 24 hours to the defendant be held so that I can file a motion for pretrial detention. This would be a must file under 907-041. Thank you.
Yeah, I'm going to exercise my discretion and not hold him based upon the facts of this specific case. unlike an armed burglary, where potentially it could be a burglar going into your home while armed to commit a burglary, this is one, the way I read it, they're family members, and the allegation is that he was part of, him and someone else, that stole items from a family member's home, and one of those items stolen was a firearm. So I'm not gonna hold him no bond, but certainly I'm gonna give you the 24 hours you're asking for to file the motion under the law and the rules of procedure. But do you want me to go ahead and handle the other two now, or just have you come back tomorrow and do all three?
Yes, sir. Well, either way is okay with the state. I would request the court honor the pretrial release conditions in the warrant.
Sure, we can, if I'm gonna go ahead and do that, then I'll go ahead and just handle the first two and just bring back the one tomorrow.
Yes, sir. The hearing date would be the same either way, so there won't be a delay.
Okay. So, sir, I'm finding probable cause based upon the warrant. The other judge has already found probable cause, and that's what led to your warrant. I'm going to set your bond at $5,000 on the grand theft of a firearm. I'm going to set it at $5,000 on the grand theft from a dwelling. I am finding probable cause, but I'm choosing not to hold you no bond, but giving the state 24 hours to file their motion on the armed burglary. So you'll be coming back tomorrow on that charge and that charge only for the state to have an opportunity to file a motion for pretrial detention. On the cases that you're here for, all three, you are going to be placed on pretrial release. So if you're able to, at some point, to post bond, you'll have to immediately check in and go see pretrial release services. But just like the little advisory at the beginning says, once I put you on pretrial, it starts right now. So for you and everybody else, just don't think that, hey, it doesn't kick in until I bond out. No, it kicks in right now. So what I'm about to tell you applies right now. And that is, you have all the standard conditions. Let's call in. Let's do, for that charge, Monday, Wednesday, Friday. So you have to report in person, sign up in person, call Monday, Wednesdays, and Fridays while your case is pending. All the standard conditions, plus special conditions 17, which says you're not allowed to have any intentional contact with the victim, directly, indirectly, to a third party, stay 500 feet away from the victim's home, vehicles, place of employment, any school the victim attends. In addition to that, you have special condition 16, which is you can't use, possess, or carry firearms, weapons, or ammunition. And you also are not allowed to have any intentional contact, directly or indirectly, with any other co-defendant. So the other person that was arrested, you can't have any contact with that person. Did that cover everything, Mr. Matthews?
Yes, Your Honor. Thank you. That's condition 23, the last one.
Okay, 23. All right, sir, we'll see you tomorrow on that one charge of burglary, armed burglary of a dwelling. Have a great day. Yeah, a pretrial on all charges. You bet. Next up, we have Marcus Joseph.
Sanderson of the Appellate Defender's Office, Your Honor. I'm asking that he be released from his own reconnaissance. He had first appearance in front of Judge Durden back on May 21st for this hold, and then they said he completed his local charges at that time. Then he had to come back to first appearances a week later on May 28th, it's still in custody. On May 28th, he was still in custody, and then it says for him to be brought back to court again on June 4th at 1 p.m. I would note this is Hillsborough County, it's one county away, they come every week. I don't know why they're not coming to get him. He's been here, over 2 weeks on a Hillsborough County driving license revoked charge of nonviolent crime. I'm asking for him to be ROR'd. They've had plenty of time to come get him as they're one county over.
So, tell me if I'm wrong, unlike a lot of what we see where it's a warrantless VOP, where a policeman decides, hey, they violated their probation, here there's actually a warrant in place. That's what it appears to be, like there's a warrant in place from a judge over in Hillsborough County, and the warrant's for no bond. That's how I read.
I don't have the warrant, so I don't know about that. All it says in the City of Lakeland arrest report is one little sentence, out of county warrant in Hillsborough County. It gives a warrant number, but it hasn't seen it, for 25 CT 01370, which is a driving charge. And it says he's taken into custody in Polk County, and that's all it says. And he's been in jail for several weeks now on this charge, and they have not come to get him. Have they not been notified?
I don't know. I don't work at the jail.
I mean, this is ridiculous. Hillsborough County comes every single week.
Mr. Matthews, I'm trying to just draw a distinction, because I think there's others that we're going to talk to later today that are in similar postures. And most of the time, we see these with warrantless VOPs, where people don't come get them. But this one sure looks like it's, and I have the benefit of the teletype between the counties. And it's from Polk Jail to Hillsborough Jail, SO, saying, hey, we hold an active traffic warrant for a failure to appear. It might be a capious if it's a failure to appear, but still it's a bench warrant for driving with license suspended, and it's specifically at no bond. I don't know why they haven't come to get him, but this one I don't feel quite as comfortable releasing him on something where there's a warrant in place. Mr. Matthews, what do you think I should do?
As I know the court is aware, technically, this state attorney's office is not a party. I would note that the charge that he pled to here that was holding him until he got transported was a DWLSR, as well as a criminal attaching the unassigned tag. On the other hand, I acknowledge what defense counsel has stated, that it's a misdemeanor charge in Hillsborough.
So when did the local charge get taken care of?
May 20th was the plea date as entered into STAC. That, sometimes that date is not exactly correct as the way it's entered, but it was more than a couple of days ago.
And I would point out, he did have first appearance the next day on May 21st. So he has been held only on this Hillsborough County case since probably May 20th.
Yeah. Ms. Smith, I don't feel comfortable doing it on this one. I think the prudent thing to do would be to continue it for a week, which might not be the same response you get from other ones we talk about today.
I mean, is there no time limitation on this at some point? I mean, he's already been here several weeks on a misdemeanor charge out of Hillsborough County.
I get it. I know. I don't disagree with you on all the facts. I'm just saying, you say, is there a time limit? Well, you tell me. Is there any authority, any rule that says I have to do what you're asking? Because if you have any authority that says, Judge, the law says you got to do what I'm asking, by golly, I'll do it.
I just wanted to know if he could just be set for, like, to be ROR'd at the next first appearance hearing, if not bought by Hillsborough County, because that's a whole nother week for them to come get them.
I don't want to do that either, because that now I'm trying to make a decision for another judge. But I wouldn't do that. Some cases I'll give a deadline, and you know I'll do this. I'll give a deadline. If they're not picked up by 5 o'clock on a certain day, then they'll be released. And that way, I don't ever bring them back in front of another judge. I don't want to overstep my bounds and tell another judge what they have to do if I'm not the one sitting in the chair. But this one I just don't feel, because it's an FTA warrant capious as opposed to a warrantless.
Yeah, I would just ask that someone, I don't know, the sheriff's office or whoever's responsible to contact Hillsborough County to let them know that he's here, so they can come get him.
So there's teletype, that was communication between the jails as recently as May 27th. Yeah, and then, of course, there may be a pickup date scheduled. I can just tell you, just common sense, is that Polk County doesn't want to keep him any longer than they have to, so they're actively burning up the phones to tell him to come get him, because turnabout's fair play. By that I mean, Hillsborough doesn't want our people over there in their jail using up their taxpayers' resources, no more than Polk wants a Hillsborough person in our jail using up our resources. So they each can do it to one another, so I suspect that it's a system in place where they both know, come get him as quick as you can, and not to abuse that system. But on this one, I'm going to just continue it a week. That's, I think, is the proper thing to do, because there is a warrant FTA capious out of Hillsborough County. So we'll set you up for 6/9 at 1 p.m. Have a great day, sir. Next up is Stephen Looney.
The court.
All right, good afternoon, Mr. Looney. You have 3 charges. You're charged with aggravated battery, second charge of aggravated battery, and then domestic violence aggravated assault. Do you want me to appoint the public defender to represent you on these charges?
Yes, sir.
Yeah, Ms. Smith is an assistant public defender. I'll provisionally appoint her office to represent you. I hold this up a lot. They probably don't see as well as you can from your vantage point now that you're here with me. This is a warrant. It was already signed by Judge Harb. He signed it about 5 days ago on the 28th. So he's already determined there's probable cause for your 3 charges. I'm going to look at his warrant. I'm going to reach the same conclusion that there's probable cause for your 3 charges. You don't have a bond, at least by him, on any of these charges, so it's no bond until first appearance is what you're having now, but I've read it, so I have a better position to make that decision. So I've read it. Having found probable cause, I've reviewed it. Based upon my review, I'm going to set your bond on the aggravated battery at $15,000. So it's per count, so it's times 2. So that'll be $30,000 for the total of the 2 ag batteries. Then on the domestic violence ag assault, I'll set your bond at $5,000, so it's $35,000 total. Judge Harb has already checked the pretrial release form, so he already has told me he wants me to put you in a pretrial release. So that's what I'll do. I'm going to place you on pretrial release. Bond is a condition of your pretrial release. If you bond out and make it to the street, you have to immediately check in with the Office of Pretrial Services here in Bartow, sign up in person, calling them with these 3 charges. I want you to call Monday, Wednesday, and Friday. You have all the standard conditions that everybody has, plus the following special conditions. You're not allowed to use, possess, or carry firearms, guns, weapons, ammunition, or knives. You're not allowed to have any intentional contact with the listed victim or victims in this case. Stay 500 feet away from them, their home, their vehicles, where they work, and where they go to school. I think we've covered it all. Yeah. Have a good day, sir.
Thank you, sir.
Next up is Richard Marshall. Oh, we can do this. Is this Mr. Marshall here? Yes, sir. Good timing. Mr. Marshall, you're charged with 3 things: battery on a police officer, resisting without violence, and resisting with violence. Do you want me to appoint a public defender to represent you?
Yes, sir.
Okay, I'll be happy to appoint Mr. Smith's office to represent you. Mr. Marshall, I read your affidavit back in my office. You can even see where I made some notes on it. So I've already reviewed this. From my review of this, I do find probable cause for these charges. I am going to set your bond at $5,000 on the 2 felonies. That would be the battery on the police officer and the resisting an officer with violence. Those are felonies. So it's $5,000 apiece. And on the resisting without, that's a misdemeanor. That's $1,000. $11,000 total. Those bonds are going to be a condition of your pretrial release. If you're able to post those bonds, you must immediately check in with pretrial services, sign up in person, and call them on Tuesdays and Thursdays. You have all the standard conditions that everybody else has, plus the following special conditions. You're not allowed to have any weapons, firearms, ammunition, or knives in your possession, and you're not allowed to have any intentional contact with the listed victims. Have a great day, sir. Alvin Miller?
Sanderson's Public Defender's Office. I do want to waive the reading of his 4 third-degree felony charges.
And I'd ask you to
Mr. Miller, you're charged with 4 third-degree felonies. They're all the same charge. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint them provisionally to represent you. I've read your affidavit. I find probable cause for each of the charges. Mr. Matthews, you want to be heard?
State's requesting GPS tracking, not necessarily house arrest, but just so his location can be known.
Sir, having found probable cause, I'm going to set your bond at $5,000 cash or surety, which is the standard bond for each of these third-degree felonies. I'm going to make those bonds conditions of pretrial release. So if you're able to post those bonds, you must immediately check in with pretrial services, sign up in person, calling them on, well, daily. You have all the standard conditions everybody has on pretrial release, plus the following special conditions. Conditions 16 and 24. 16 says you're not allowed to possess or carry any firearms, guns, weapons, ammunition, or knives. 24 says I'm going to put you on GPS monitor, not house arrest, so you're not confined to your home. But I do want you to be held in the Polk County Jail after posting bond and not released until you've been equipped with a GPS monitor. I want to know where you go at all times, from a standpoint of, and Mr. Matthews, normally I would tell them want to know where they go at all times and stay away from the victim. Here, it's to stay away from places by statute they're not allowed to frequent, or how is that? Purpose of the GPS naturally
Well,
is.
considering the nature of the multiple charges, just want to be sure that law enforcement knows where he is, Judge. As far as violating any other statutory requirements, he's already required to follow those. Breaking the law would be a violation of pretrial release conditions.
Sure. All right. No house arrest, just a GPS monitor. You'll be allowed to, because you're not requesting house arrest, you want to know where he's at. Yeah. So yes, sir, GPS monitor, as well as condition 16, no weapons or firearms. Have a great day.
Okay.
That brings us to Robert Mills. Mr. Mills, you're charged with 3 crimes. They are dealing in stolen property, passing a forged or altered instrument, and use of personal information without consent totaling $50,000 in possible damages. Sir, do you want me to appoint the public defender to represent you?
Yes, please.
I'll go ahead and provisionally appoint that office to represent you. I've reviewed the warrant. Judge Harb has already reviewed it a few days ago, the affidavit that is, and he signed the warrant which led to your arrest. So he's already found probable cause, signed the warrant. I reviewed the affidavit and I find probable cause as well based upon his warrant. I'm going to set your bond on the dealing in stolen property at $15,000. I'm going to set your bond on the passing a forged or altered instrument. That's a 3rd-degree felony. I'm going to set that bond at $5,000. And the big one is the 1st-degree felony, punishable up to 30 years in prison. That's the unlawful use of personal information of another without consent, $50,000 plus. I'm going to set that bond at $30,000. Total of all the bonds is $50,000. Going to make those bonds conditions of pretrial release, because that's what Judge Harb wanted. So if you're able to post those bonds, you must immediately check in with pretrial services here in Bartow. Sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions plus special condition number 17, which is you're not allowed to have any intentional contact in any form, directly, indirectly, or through a third party with the alleged victim. This means you must stay 500 feet away from them, their home, their vehicles, where they work, or where they go to school. Have a nice day, sir. And that brings us to Juan Roman.
Sanderson, Defender's Office. I want to waive the reading of the charge. He's here for violating his probation on.
Mr. Roman, you're here for a violation of probation on a felony case number. Do you want me to appoint the public defender?
Yes, Your Honor.
I'll provisionally appoint them, finding a probable cause based upon the warrant, holding you no bond. You'll go see the circuit judge on June 26th. Have a great day.
Thank you.
You bet. And I think our last one from South County is John Vistacci.
Yes, Your Honor.
Mr. Vistacci, you're charged with 4 crimes, two counts of these 2 following crimes. Criminal use of personal identification of another, 2 counts, which is a 3rd-degree felony, and uttering a false instrument, also 2 counts, and each of those is a 3rd-degree felony. Do you want the public defender appointed to represent you?
Yes.
I'll provisionally appoint that office to represent you. Sir, I've looked over the Lakeland Police Department affidavit. I read it in its entirety back in my office, finding probable cause, also recognizing that you don't have any ties to this area. You're a resident of New York. Based upon what I've reviewed and your lack of ties to the community, I'm going to set your bond on each of these 3rd-degree felonies at $7,500. You add it all up, that's $30,000. Going to make those bonds conditions of pretrial release. If you're able to post those bonds, immediately check in with pretrial services, sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions plus special condition 17, which is you're not allowed to have any intentional contact with the listed victims. You must stay 500 feet away from them, their home, their vehicles, where they work, or where they go to school. Mr. Matthews, anything else you're asking for on this one?
No, Your Honor, thank you.
Have a great day, sir. All right, I think that's it for South County deputies. Have a great rest of your day. Moving on to the ladies. First up, we have Tiana Bennett Perry. Can you look?
Yes, Your Honor.
Can you look to see if this young lady has any prior record? Ma'am, you're charged with domestic battery. Do you want me to appoint the public defender to represent you?
Yes, Your Honor.
I'll provisionally appoint that office to represent you. I've reviewed your affidavit back in my office, and I do find probable cause, which was very curious to see if you had any prior record. Looks like you might have lived in Georgia. Looks like there's some things from Gwinnett County up there. Let's see what it is. Looks like it's driving on suspended license. Let's see if there's anything else. Yeah, just a driving while license suspended. All right. And she wasn't recommended for straight pretrial, and that was, I guess, based upon the victim's wishes?
Based on her prior history.
Oh, just on the driving. Ma'am, I'm going to let you out of jail. I'll tell you what, I'll make a deal with you. Are you promising me that if I let you out of jail without posting any money, that you'll come back to court when I tell you to?
Promise.
All right. All right. They call that well, there's believe it or not, you hear the phrase ROR is called recognizance bond. I'm not RORing you. I'm going to straight pretrial release you, but just a kind of a point of reference. When people are ROR, released on their own recognizance, that's a bond. The bond is my word is my bond kind of thing. It's based upon your promise. But in your case, having reviewed everything, I think that I'm going to straight pretrial release you, which means you'll be getting out of jail today without posting any money. Okay? You might not make it there today, so that means first thing tomorrow, you got to come back down here to Bartow and sign up with pretrial services. Sign up with them in person, calling them once a week while your case is pending, and that's on Tuesdays. Every week while your case is still pending, you got to call them. While on pretrial, you have all the standard conditions that everybody has, plus the following special conditions. You're not allowed to have any intentional contact with the alleged victim. And I've read what the relationship is, but you can't have any contact with her, directly, indirectly, or through a third party. Stay 500 feet away from her home that she lives in, her vehicles, where she works, or where she goes to school. Now, I will tell you the tricky part here is that I'm gathering you're saying to me, hey, Judge, where I live, that's my house. She was there when she was there because I let her stay there. Is that what you're going to tell me?
No, Your Honor, she actually moved. She did move,
Right.
and the officers were there.
Yeah, and that's where it's getting a little tricky. The policeman put down your address and hers to be the same, but it does appear to me, based upon what I read, that she no longer lives there. What I'm saying to you is, if she's living there when you get out, and that's her legal residence, you're going to have to find somewhere else to stay until she's either evicted, or she moves out on her own, or some judge signs some document that requires her to leave. But if she doesn't live there, she has moved out like it appears she has, then you get to go back to the home that you have, but you got to stay 500 feet away from whatever house she lives in, okay? So
Yes, Your
you
Honor.
have special conditions 16 and 17, and I'll even throw in 18 in an abundance of caution. 18's special condition says, if you get out of jail, you can't call her and say, hey, are you still living at the house, or did you move out like I think you did? You can't call her because that would be violating your pretrial. But I am, in an abundance of caution, going to let you go back to that home with the police to get your stuff. So hypothetically, if she's living there now, then you get to go back with the police within 48 hours of getting out of jail to get all your essentials, like your medicine, your clothing, your checkbook, all those things like that. And if she, but if she doesn't live there, of course, you get to go back, okay? Any questions?
No, Your Honor.
All right, have a great day, ma'am.
Thank you.
This court date I'm going to give her, is that accurate? Yes. And is she going to be, ma'am, real quick? Just so I can get you to promise again, your court date is July 2nd. Is that in Bartow or is that in? So ma'am, real quick, because I wanted, you're a Lakeland Police Department case. They investigated it. So now that I'm letting you out of jail, your court date's not going to be at the Bartow Courthouse. It's going to be at the courthouse in Lakeland. Right
Yeah.
there, it's old Searstown, right there, right off Memorial in Ingram. There's a courthouse. So that's where you go for your court date. It's going to be on
It's the right one.
June the 24th, about 3 weeks from now, June the 24th at 8:30. Okay?
Okay,
Have a great
Okay.
day.
thank you.
You bet. All right, we are up to Carly Christopel is charged with violating her probation on charges of possession of drug paraphernalia and another misdemeanor. Ma'am, do you want me to appoint the public defender?
Yes.
I'll appoint that office provisionally. Looking at Judge Harb's warrant, finding probable cause, he wants you held no bond. You'll go see him on June the 29th. Have a great day.
Thanks.
You bet. We are up to Michelle Del Rio.
Sandra Smith, Flood Defender's Office. I have a stipulation with the state that there should be a probable cause for a secondary misdemeanor on this case.
Okay. Ms. Del Rio, you're charged with first-degree misdemeanor driving while license suspended. It's a first degree allegedly based upon a prior for that same crime. Do you want me to appoint the public defender?
Yes.
I'll provisionally appoint that office to represent you. Ma'am, I've looked over the affidavit by the sheriff, finding probable cause for the M2, which means they did not sufficiently prove that you had a prior. So I'm only going to find probable cause for the second-degree misdemeanor, not the first-degree misdemeanor. I'm going to set your bond at $1,000. Have a great day, ma'am.
You won't get any charge deduction,
I'll tell you what, ma'am, I'll set your bond at $250.
thank you.
Have a great day. Because that is the standard bond for an M2. Next up, we have Ashley Lancaster. We already did, so now we're up to Mrs. Talia Mosi Brown. Ms. Mosi Brown, you're charged with domestic violence battery. Are you wanting me to appoint the public defender?
Yes,
I'll provisionally appoint that office to represent you. I've looked over the Haines City Police Department affidavit. I have it here in front of me. I find that there's probable cause. I'm going to set your bond at $2,500 and make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services. Sign up in person, calling them on Tuesdays, all the standard conditions plus special conditions 16, 17, and 18, which says you can't have weapons or firearms or ammunition in your possession. You can't have any intentional contact with the victim. Stay 500 feet away from him, his home, his vehicles, where he works or where he goes to school. And you are allowed to go back to that home one time with the police within 48 hours of your release from custody with the police to retrieve your essential items like medicine and clothing. Have a great day, man. Tuesday, yeah. Tuesday. Catherine Norris? Ms. Norris, you were charged with domestic violence battery. Are you planning on hiring a lawyer, or do you want the public defender?
Public defender.
Ms. Norris, I'll provisionally appoint the public defender to represent you.
Sandra Smith, what, public
Ms. Norris have a prior record.
Good, Your Honor.
All right.
Recommended for straight control use.
I got it, yeah, she has been. I just wanted to check to make sure there's no prior record. Ms. Norris, I'm finding probable cause because I read your affidavit from the police. You have been recommended for straight pretrial release. I'll go along with that since you have no prior record. So like the other young lady a moment ago, you're promising me you're going to show up to court. In a minute, I'm going to give you that court date so you get it straight from the horse's mouth. But you're going to be on straight pretrial release, which means you don't have to post any monetary bond. You'll be getting out of jail sometime today. Probably too late to get there today, so you'll have to go tomorrow to pretrial services here in Bartow. Sign up in person, calling them on Tuesdays while your case is pending. You have all the standard conditions that everybody has while on pretrial release, plus the following special conditions. 16, 17, and based upon your address, I'm going to do 18. And what that means is 16 is you can't have any weapons or firearms in your possession. Okay, you can't have any of those, otherwise you'll get in trouble, get yourself in trouble. 17 says you can't have any contact with the alleged victim, and I understand the relationship. It looks like it's your daughter. So you can't have any contact with your daughter. You have to stay 500 feet away from her, her home, her vehicles, where she works or where she goes to school. Now, I can appreciate that based upon what I've read, I gather that this is your home and she's there because you allow her to be there. And as much as I appreciate that, the way the law looks at that, this is her legal residence. So if that's her legal residence, I can't make her get out. Here's how this works. I tell everybody, I'm a judge, I wear a robe, but I don't have unlimited power. I can't walk down the street and pick somebody out and say, hey, you got to move out of your house because I'm a judge. What gives me power over you is you've been charged with a crime. She hasn't been, okay? I'm not pretending like I'm an eviction judge, because if I was an eviction judge, I would have power over her based upon the filing. But I'm not. I'm not a divorce judge or anything like that. I'm a criminal judge doing first appearances. So I don't tell her she has to move out. So you have to stay 500 feet away from her, her home, her vehicles, where she works or where she goes to school. So even if you pay the bills and she doesn't, that's her legal residence, and she's still there, you're going to have to find somewhere else to go, okay, until she's either been evicted or something changes. Because of that, the potential for that to happen, I'm going to do condition 18, which says, when you get out of jail, you get to go back to that home one time that she lives in within 48 hours with the police to get your stuff, your essentials, medicine, clothing, work tools, laptops, things like that. The policeman's not going to sit around and let you load up a U-Haul. They're not going to spend that kind of time. So it's really meant to be quick, get your stuff and go. And once you go with the police, if you discover that her bedroom's empty and all her clothes are gone and she's moved out, well, then you can go through pretrial services and get the thumbs up to go back to that house since she no longer lives there. My goal is to keep you 500 feet away from whatever house she lives in. Okay? Make sense?
Yes.
All right. Any questions?
No.
Have a great day, ma'am.
Thank you.
You bet. Sherry Smith?
Sanderson, Polk Defender's Office. The pretrial paperwork said that alleged victim does want to have contact with her and doesn't want to press charges. And I would point out that the affidavit is that she alleged to have grabbed his beard and pulled on it. So I was going to ask for straight pretrial release with no violent contact with the alleged victim.
Does she have any record? No known criminal history. You already beat me to it.
But she does present in Texas, which is why she was not recommended.
Yeah, they have her down living a long ways away. Yep. Miss Smith, I'll tell you what, if you resided in Polk County, I probably would have straight pretrial released you. But if you heard my speech at the beginning, bond's not meant to punish anybody. You guys are innocent until proven guilty. Okay? They got to prove you guilty. Bond's meant to make sure you come back to court. And you don't live in Florida. You don't live anywhere close to Florida. So if I just let you out of jail with a promise to come back, I don't feel nearly as confident that you'll do what you say you'll do. And that's what's probably preventing me from doing the straight pretrial.
Yes, Ron.
Yeah. All right. So, ma'am, you're charged with domestic battery. Do you want me to appoint the public defender to represent you?
Yes, Your Honor.
I'll go ahead and appoint that office to represent you. I've looked over the affidavit, and I do find probable cause for the charge. I will tell you that a domestic battery is standard bond. Normally, most judges would do a $5,000, depending on the allegations. Many people would consider that a standard bond. I did review the allegations. I'm not going to give you the $5,000. I do believe a reduction is appropriate, but I'm not willing to go all the way down to no bond. So what I'm going to do is I'm going to set your bond at $1,000. Going to make that bond a condition of pretrial release. If you're able to post that bond, you must immediately check in with the Office of Pretrial Release, sign up with them in person, calling them on Tuesdays while your case is pending. You have all the standard conditions that everybody else has, plus the following special conditions. 16 says you're not allowed to have any weapons, firearms, ammunition, or knives. Because the alleged victim does want to have contact with you, Pretrial has reached out to him, and he says, yeah, he wants to have contact with you. And just like Ms. Smith says, he's indicated that he doesn't want to pursue any charges. Well, ultimately, that's up to the state attorney, not the alleged victim, but at least let his feelings be known. So what I'm going to do is, based upon his wishes, I am going to allow you to have contact with him, but this contact is prohibited from being physically or verbally threatening. You can't be violent or abusive in any manner whatsoever. We call that nonviolent contact. So,
You know, we should be allowed to live in Texas. Her husband also lives in Texas.
yeah, so we'll delete standard condition 10. So ma'am, if you post that bond, you get to go back to Texas. You just got to come to court when you're supposed to, or hire an attorney who will come in your place, or in your case, you have the public defender. So you have to talk to them and see if they want you to come to court, or if they'll handle things without you being there, okay?
Yes, sir.
So, check 27, and what was 27?
That should be returned.
Yeah, so we'll delete condition 10, or as you said, 27 is that she gets to return to Texas if she chooses to. All right. No, she doesn't have to, I mean, that's up between her and her attorney if she wants us to attend to all of them. So at some point, if it results in a trial, well, you got to be here. At some point, if it results in a plea,
Yes, sir.
well, you got to be here. But you
Yes,
and your
sir.
attorney can decide when they want you to come to court or when they'll waive your presence. Have a nice day, ma'am.
Thank you.
You bet. Cynthia Thales?
Yes, Your Honor.
Good. Good afternoon, ma'am. You are charged with burglary with an assault or a battery, petty theft from a dwelling, and knowingly giving false information to a police officer during an alleged crime. Do you want me to appoint the public defender to represent you?
Yes.
I'll provisionally appoint that office to represent you. Ma'am, I've looked over the affidavit from the sheriff. There is probable cause for all the charges. Mr. Matthews, go right ahead.
Judge, the count of burglary with an assault or battery, my reading of the affidavit is that it is charging burglary with assault. While it did involve a conveyance, that conveyance is alleged to have been inside of an attached garage to a dwelling. So my reading of it is that it is before the court as an F1 PBL of a dwelling. The state is requesting that the court hold the accused no bond based on that charge. If the court is not so inclined, I am requesting 24 hours to file a motion for pretrial detention, as this is a must file under 907041. I can make argument regarding why I think the court should hold her, but thank you.
Ms. Smith, your thoughts on that?
Well, it sounds like either way, if the court
Yeah.
decides to give a bond, the state's going to file a motion and come back tomorrow anyway, holding her no bond and have their hearing, so I would defer to the court.
Yeah, and this one I feel more comfortable than the last one. It's not your classic burglar in the middle of the night with a baseball bat doing you harm, but the allegations are you entered a man's home and assaulted him, which...
How did I assaulted him?
No, don't talk about it. I'm just letting you know why I differentiate yours from the other gentleman. So what I'm going to do, ma'am, is having found probable cause, I'm going to hold you no bond on the burglary with an assault. I'll set your bond on the petty theft at $1,000 and your bond on the knowingly giving false information to a police officer at $1,000. Those bonds are going to be conditions of pretrial release. If you're able to at some point post bond and be released, you'll be on pretrial services, which means you have to sign up in person and call them on Tuesdays and Thursdays, all the standard conditions plus special conditions 16 and 17, which is you can't have weapons or firearms and you can't have any intentional contact with the victim. Stay 500 feet away from him, his home, his vehicle, where he works and where he goes to school. Have a great day, ma'am.
I have a question. What does no bond mean?
It means it doesn't matter how much money you have, you can't post bond and get out. You're going to be held in jail without being able to get out until another judge changes that.
Okay.
Or the case gets resolved some way or another. Have a great day, ma'am. Johnny Todd?
Yes, sir.
Ms. Todd, you're charged with possession of fentanyl, possession of methamphetamine, and possession of drug paraphernalia. Do you want me to appoint the public defender?
Please.
I'll provisionally appoint that office. I've looked over the sheriff's affidavit. There is probable cause. Taking a look, they have you down as having an extensive criminal history. I'm going to set your bond at $5,000 on the fentanyl, $5,000 on the meth, and $1,000 on the paraphernalia. Have a great
Yes.
day.
Thank you.
You bet. Michaelan Adams?
Yes, sir.
I think we're done with the ladies. All right, on to the gentlemen. Mr. Adams, you are charged with failing to appear for court on a charge of battery. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint that office provisionally. Looking at Judge Cole's bench warrant, finding probable cause, he set your bond at $5,000. Have a great day.
Thank you.
Gregory Bacon is charged with trespass. Sir, do you want me to appoint the public defender?
What would be the penalty on it if we just went ahead with it today?
Well, I don't think, Mr. Matthews, have you made an offer on this today?
We don't make the offer until the information is filed. That typically will be within 21 days of first appearance.
There you go, sir. He hasn't made an offer for you. So do you want me to appoint the public defender?
Sure.
I'll provisionally appoint that office.
I'm sorry, I didn't hear the offer. What was it?
There was
No
a
offer, okay.
He
Okay,
hasn't
okay.
made a formal decision on what to file, if to file or what to file.
Okay.
So I've looked over the Winter Haven PD affidavit, finding probable cause for setting your bond at $1,000. Have a great
Okay.
day. We're on to Schuler Berry Austin.
Yes, sir. It's Skylar.
I'm sorry, sir, Skylar.
Yes, sir.
Sir, you have 3 separate VOPs. What puts you on probation are marijuana possession, paraphernalia possession, and carrying a concealed weapon. Do you want the public defender for this VOP?
Yes, sir.
I'll appoint the public defender, finding probable cause based upon Judge Harb's warrant. He wants you held no bond. You'll be held no bond, and you'll go see him on June the 29th. Have a great day. Shamar Buggs.
I'll ask you heard on this one.
Yes, sir.
Mr. Buggs, you're here on 16 charges. They are, let me count them, 1, 2, 3, 4, 5, 6, 7, 8, 9 charges that appears of, 8 charges of burglary of a dwelling. Then you have 1, 2, 3, 4, 5, 6, 7 charges of grand theft from a dwelling, and the 16th charge happens to be dealing in stolen property. All of those are felonies. Sir, do you want me to appoint the public defender?
Yes.
I'll provisionally appoint that office to represent you. I'm looking at a capias. The capias was generated after the state filed formal charges, so they've already done their investigation. They've already filed these formal charges. So I find probable cause. Mr. Matthews, you want to be heard as it relates to bonds?
Yes, Your Honor, with regard to each of the 8 counts of burglary of an occupied dwelling or of a dwelling, Judge, the state's filing a motion for pretrial detention in each of those. Burglary of a dwelling is an enumerated dangerous offense. Even as an F2, it would still qualify under 907-041 5C5. Providing a hard copy of the motion to the appointing counsel. May I approach?
Thank you.
Yes, sir. Respectfully request the court review that motion for facial sufficiency, and if so found, hold the accused no bond on those counts until a hearing on that motion, which should be set for next week on Monday at 1 o'clock on the A2 docket. Thank you.
Ms. Smith, anything from the defense? No. All right. Sir, I'm finding probable cause, as I said, for all 16 charges. On the grand thefts, the bonds have already been set at $5,000 apiece. There is a typo on the dealing in stolen property. They have it down as $1,000. That's clearly wrong.
That would be my argument, Judge.
Yeah, it's clearly wrong. So, sir, it's $5,000 on the 7 grand thefts. The dealing in stolen property is a second-degree felony punishable up to 15 years in prison. I'll set your bond on that at $15,000. That's the typo. They missed the 5. $15,000. I have reviewed the motion for pretrial detention filed by the state. It's filed pursuant to Florida Rule of Criminal Procedure 3.132 and Florida law, Florida statute section 907.041 5C5. After reviewing this 2-page document, I find it's legally and facially sufficient. As a result of that, on each of the 8 burglaries, you're going to be held no bond, and I'll send you to see a circuit judge. And you said that date would be?
It would be next Monday at 1 o'clock on the A2 docket.
Yep, a week from yesterday, June the 8th at 1 p.m. Have a nice day, sir. I didn't put any pretrial on this. I suppose that'll be addressed if there is going to be any.
It will not address the charges on which the bond was set today, as they will not be before the judge next Monday.
Right. So let's do this. I'm going to put him on pretrial release with special conditions 16 and 17. And that's for all the grand thefts. So sir, real quick, on the grand thefts, since you won't be going to see the judge on those and the dealing and stolen, I am going to make those bonds I gave you conditions of pretrial release. So if at some point you do get out of jail, which that's if, it depends on what happens next week with the judge there and beyond. But if you some point hit the streets, you have to immediately go see pretrial services, sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions plus special conditions, 16 and 17. I think that's probably sufficient, which is no weapons or firearms, and you can't have any contact with the alleged victims or their homes, and stay away, what number is that? Stay away from the event locations. 21. So no contact with the event location where these thefts occurred. Have a nice day, sir. Well, you can put it on the burglaries, because it still has to go, the bond will be addressed there. So yes, pretty much on all 16, give him pretrial. It gets a little confusing, but no reason why I couldn't do it on all 16.
I agree, Judge, and some of, the judge that presides over A2 rotates, but it is a common question whether any conditions were placed on those charges. I think the distinction comes down between bond, which is the conditions of release, and the bail, which is the dollar amount. And if there is no bail or no dollar amount, if they're held no bond, that is something that can be done on the A2 document.
So yeah, we're doing all 16 of it then, same conditions. Terrence Butler?
Yes, sir.
Good afternoon, sir. You're charged with 4 charges. They are possession of cannabis not more than 20 grams, possession of drug paraphernalia, resisting an officer without violence, and lastly, drugs, keeping a shop or a vehicle for drug use. That's a misdemeanor. You want me to appoint the public defender?
Yes, sir.
I'll provisionally appoint them to represent you. I find probable cause based upon my review of this document. I am also aware that you currently have an open charge, a felony charge, contained in 26 CF 4673. Does the state wish to be heard as it relates to bonds and possible Parker?
State's requesting a Parker in that named case. The charge in that was by information, delinquent in possession of a firearm, ammunition, or a concealed weapon.
Ms. Smith, anything from you?
But what are the charges in that?
Delinquent in possession of a firearm, ammunition, or concealed weapon.
Obviously, we would ask the court to use its discretion and not par for him.
All right, Mr. Butler, having reviewed the affidavit that you're here for, the 4 charges, I find probable cause. I'm going to set your bond on each of these 4 charges at $2,000 apiece, so it's $8,000 total. And because you picked up these 4 new charges while you're out on bond or pretrial release on a pending felony, I am going to revoke your bond and pretrial release on that case and hold you no bond pursuant to the authority of Parker versus State. Do you have an attorney on that old case? If you do, they'll continue to represent you. If you don't, I will appoint the public defender.
Show me a push ball.
Okay, have a nice day, sir. Next up, we have Joshua Caldwell Feggins. Sir, you're charged with a warrantless VOP from Hillsborough County. It looks like it's for a charge of fleeing to elude. I cannot appoint a public defender in Polk County for a Hillsborough County charge, but you can certainly hire a lawyer if you want. or wait till you get back to Tampa and ask for a public defender there. I do find
Yeah.
probable cause to hold you. Ms. Smith,
I know he had a local charge. I don't know when he bonded out on the local charge, so I'm unable to tell how long ago that was.
yeah,
It was 2 days ago. My parents posted the bond, but I've been here for 2 weeks already.
Okay, so he posted the bond a couple days ago then.
yeah. Yes, sir. So now the way it works is, it gets a little hairy, and not everybody does this regularly like we do, get familiar with how it works, but when you get picked up on a Polk charge and you have a warrant from somewhere else, well, Polk's not gonna let you go to that other county until you're done with your Polk stuff, or either you bond out on the Polk stuff.
Yes, I understand. I go to court Friday for the local charge, so I already know.
Okay, so, and the tricky part is if you bond it out on the local charge, and you're still in our jail, well, they'll make arrangements to get you over there. But hypothetically, if Hillsborough came and got you, you're in Hillsborough and you missed court on Friday, now you might have a warrant from over here because you missed court on Friday. So it gets a little hairy. The bottom line is if you just posted bond on the local charge, then they need to have a reasonable amount of time to come get you. Polk doesn't want to pay for you to stay in the Polk jail on Hillsborough charges, and neither does Hillsborough. Hillsborough doesn't want to pay to have Polk County people on Polk charges housed over there. So both of them understand that. They want to go quickly to pick their people up from the neighboring counties. So here's what we're going to do. Polk will notify Hillsborough that you're available to be picked up. Many times, not always, but many times you're gone between now and the next time we schedule you to come back to see me, which is next week. But every once in a while, for whatever reason, you haven't been picked up. If for some reason you have not been picked up a week from today, they'll bring you back to talk about it with a judge. I don't know what that judge will do, but you guys can discuss what's imminently going to happen or what needs to be done if you haven't been picked up, okay? Have a great day, sir. That brings us to Randall Cortez Garcia.
Yes, Your Honor.
Sir, you're charged with a warrantless VOP. And best I can tell, it looks like it's a Polk charge, but it might have been supervised out of Orange County. Is that how y'all interpret that? Because I have arrest documentation from Orange County, but clearly you're here in Polk County.
He's on probation in Polk County. He
Right.
was arrested in Orange County, I think, on another matter which violated his probation in Polk County.
Right.
So he's on probation in Polk County on 3 charges in 2023 CF 01663.
Yeah. So the point I was trying to make is the people who are on probation in Polk County for a Polk County charge, they're allowed on probation to move to another county. Well, you're still a Polk County charge, but you're being supervised over there. And that's what happened. You got arrested over there, but what was holding you, or what the charge is for a violation of a Polk County case. So, sir, do you want me to appoint the public defender to represent you on this VOP?
Yes, sir.
I'll appoint the public defender to represent you. I've looked over the Orange County probation officer's documentation. I do find probable cause for the charges. When I hold you no bond, you'll go see the probation judge, Judge Harp, on June the 29th. Have a great day.
Thank you, you as well.
You bet, sir. Next up, we have Hunter Gilly.
Sanders Smith Public Defender's Office.
Yes,
He's
Your Honor.
recommending for straight pre-trial release, so I was going to ask for that also.
Mr. Gilly, you're charged with domestic battery. Do you want me to appoint the public defender to represent you?
Yes, Your Honor.
All right, I'll provisionally appoint that office to represent you. Sir, I've looked over the Bartow Police Department affidavit. From my review of this document, I do find there's probable cause to hold you. Yeah, it's frozen, so I'm talking slowly. So, Mr. Gilly, can you hear me?
Yes, Your Honor.
Yeah, I thought you could. Our camera's froze, so I want to make sure I see you before I go any further. I can hear you, but I want to just make sure I can see you. So give us a minute. Sometimes where you guys are, between us and Frostproof, or us and where you guys are, there's bad weather and this kind of thing happens. Any thoughts on
I'll let him know.
Yeah.
Bailiff Fletcher, your camera's frozen. We can hear him, but we can't see him. Can't see us at all? Or we're still on the last defendant
Yeah, we
as
have
far as the video is concerned. I have to log off and log back in. There we go.
All right, Mr. Gilly, I can see you now. Thank you. Sir, you've been recommended for straight pretrial release. He has no prior record. Then I'm going to go along with that. Sir, that means you'll be getting out of jail without posting any monetary bond. You're probably going to get out too late today to go sign up today, so you'll have to do it tomorrow. The office is right next to county probation, right there. I gather you're familiar with Bartow based upon your affidavit. So you just go down Highway 17 like you're going to Fort Meade. Before you leave Bartow, on the right side of the road is county probation. Right next to that is pretrial services. So you'll have to head over there tomorrow morning, first thing, sign up with them, calling them on Tuesdays. You have all the standard conditions everybody else has, plus the following special conditions. Let me take a look to see what the alleged victim said. Pretrial reached out to her but was unable to get a hold of her, so I don't know what her position is on contact. So I'm going to play it safe. I'm going to tell you that you're not allowed to have weapons or firearms or ammunition in your possession while on pretrial release. You're not allowed to have any intentional contact with her. Zero. And that's, you know, it is what it is. No contact means no contact. And guess what? If you're on pretrial release for a domestic charge and you violate, that's a brand new charge. And if you've seen what happens today already, when you out on bond with a charge or pretrial and you pick up a new charge, that old Parker thing comes into play, and you don't want that. So make sure you follow these conditions, which are no weapons or firearms, no intentional contact with the victim, stay 500 feet away from her home, her vehicle, where she works or where she goes to school. And because you lived with her prior to you being arrested, you do get to go back there one time within 48 hours with the police to retrieve your essentials, things like medicine and clothing. Have a great day, sir.
Thank you, Your Honor.
You bet. Next up is Jacob Embody.
Yes,
Mr.
sir.
Embody, you're charged with possession of cannabis known as marijuana, possession of drug paraphernalia, and possession of methamphetamine. You want me to appoint the public defender?
Yes.
I'll appoint the public defender to represent you.
Sanderson Public Defender's Office, I would ask for no more than presumptive bonds on this. He's been found incompetent, received in a 2023 CF 0053441BA case way back on April 22nd, 2024. The case is still pending because he has to keep getting reevaluated over and over again, but he was on conditional release, so I would ask for no higher than presumptive bond since he's still incompetent, proceed on that case.
Pretrial had told me he's in F8, and I was just going to make sure that wasn't drug court, but instead was con court. All right, sir, having found probable cause, going to set your bond at the standard bond, $1,000 for the cannabis, $1,000 for the paraphernalia, and $5,000 for the methamphetamine. Have a nice day, sir. Jacob Jackson? Sir, you're charged with sale of cannabis within 1,000 feet of a church. That is a second-degree felony punishable up to 15 years in prison. Do you want the public defender appointed to represent you?
Yes, sir.
I'll appoint that office to represent you. Looked over a warrant. It's already been signed by Judge Dana Moore. Finding probable cause. Going to set your bond at $15,000, making it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services. Sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions, plus Judge Moore wants you to have condition 16, which is you may not use, possess, or carry firearms, weapons, ammunition, or knives. And she also wants you to stay 500 feet away from the incident location. So wherever this arrest took place, wherever they allege that you were selling marijuana, you have to stay 500 feet away from that location, okay? Have a great day, sir. Joshua Jones?
Yes, sir.
Sir, you're charged with a warrantless VOP from Orange County on a charge of battery. I cannot appoint a public defender because it's an Orange County case. You can hire a lawyer or wait till you get back to the public defender, to Orange County to ask for the public defender. Ms. Smith, as far as how long, do you know how long he's been here without having a local charge holding him?
I'm trying to figure that out. I'm not quite sure on this one.
Yeah, the teletype that was sent over to them is way back from March the 18th. The teletype went from Polk County Jail to Orange County Jail, saying, hey, we got him on a warrantless VOP. He's completed his local charges and is ready for pickup.
Well,
It's hard for me to believe he's been here 2.5 months on a warrantless VOP. Is that what? So they might have jumped the gun by telling them that he's ready for pickup.
I'm trying to figure out, I thought he had resolved his local charges, so I'm not
I believe.
quite sure. When yesterday?
Okay.
You got community control yesterday. Okay, so this is the first.
When we were talking earlier about giving him a release date, that other gentleman.
I think that was the only one I had that was concerned
This was the
about.
one that I was in the back of my head thinking, man, has this guy been in there 2+ months waiting for someone to come get him? That was one that was going to be an easier argument for you to make and easier to convince me of. But even though this says 3/18, it sounds like he just resolved it yesterday.
Community control yesterday, so we'll
Yeah.
ask for a 5 or 7 day review hearing.
Yeah.
We just only had the one that I argued.
Gotcha. So, sir, find probable cause. You don't get the public defender, you can hire a lawyer. I'm going to hold you no bond. Now that your local charge is done, Polk's going to want to get you out of our jail, make them come get you and pay for you. So we're going to notify them to come get you. If for some reason you're still here a week from today, on the 9th, they'll bring you back so you can talk it over with the judge, see what happens next. Have a great day. Willie Kirkland?
Yes.
Mr. Kirkland, you're here for warrantless VOP. What put you on probation was possession of paraphernalia and possession of a canceled or revoked DL. Do you want me to appoint the public defender?
Yes, Your Honor.
I'll appoint them to represent you. Finding probable cause based upon your probation officer's affidavit. Your PO alleges that you tested positive for cocaine at the probation office when you went to see him in North Lakeland. But finding probable cause is going to hold you no bond. We'll set you over to see the circuit judge on June the 29th. Have a great day. That brings us to Jawanski McWilliams.
Yes, sir.
Sir, you're charged with a warrantless VOP. What put you on probation was domestic violence battery by strangulation. Do you want me to appoint the public defender?
I have a paid lawyer.
You're going to hire a lawyer, you say?
Yes, ma'am. Yes, sir.
Okay, if you change your mind and want the public defender, you can always ask at any time in the future. But we'll put you down and you're going to hire your own attorney. I've looked over your probation officer's affidavit. Much like the last gentleman, your probation officer alleges that you tested positive for THC or marijuana when you went to see them at your probation officer's office in Lakeland. So I'm finding probable cause to hold you, no bond. Going to send you to see the judge on June the 29th. Have a great day.
Yes, sir.
Thank you. Anthony Ortiz. Mr. Ortiz, you're charged with resisting without violence and driving while license suspended or revoked with knowledge. Do you want the public defender?
Yes.
I'll appoint the public defender to represent you. Sir, I've looked over your sheriff's office affidavit, and I do find probable cause for these 2 charges. I also take note that you were already in jail a couple days ago and you bonded out on May the 29th. So after bonding out on May the 29th, you got yourself back arrested on June the 1st. So I'm going to set your bond on these. I'm going to enhance the bond. It'll be $2,000 on the resisting without, $500 on the driving while license suspended. Mr. Matthews, are you requesting that he be Parkered on this?
Yes, sir. And I note that the pretrial is not giving the case number. I'm trying to look that up right this minute.
He bonded for the first appearance, but here's the.
So he just didn't have what were the charges over the weekend? Okay, so he had a battery charge, bonded out, and now he picked up these two new charges. And you don't have a case number for him?
I'm looking.
Sure.
It has not been added to stack yet. That is not unusual for a case coming out of the weekend.
Right.
So I would have to rely on showcase, but I think the clerk is far better at.
All right, Mr. Ortiz, I am going to revoke your bond on the misdemeanor battery charge that you bonded out over the weekend. Going to hold you no bond pursuant to the authority of Parker versus State, and appoint the public defender on that case if you'd like me to. Do you want me to appoint the public defender? So now you have him on all your cases. You just can't bond out on the old one, okay? Have a good day, sir.
Yes. Do I have court?
Yeah, you have court on all the cases. Your arraignment on the resisting without and the driving while license suspended is going to be with Judge Gibson on June the 19th. I suspect that other one is a battery. It'll go on that same day. As far as, we have no identifying, Ms. AK, what do you suppose we do to document the Parker on that weekend case? Do we have an arrest number that we can give, a bookend number? That something that we can capture to make sure that even though the clerks haven't given him a...
Which day did he go to first appearance this weekend? Do we know?
He didn't go to first appearance, he bonded out before. So it would have to be an arrest number versus a, so he didn't go to first appearance, but he bonded out prior to.
And I'm not able to search some outside of first appearance.
See any first appearance paperwork in. The booking number for him was 2616192.
You get that? So we can at least reference the Parker connected to the bookend number. And say it again?
2616192.
Okay. So he'll be Parkered on that. All right, sir, have a great day. I think your court date is going to be June the 19th for both. That's the jail arraignments. Moving right along, Calvin Pinkney.
How you doing?
Good, sir.
I would like to be heard regarding bond. I know it's a warrant, but I just want to be heard.
Absolutely. Mr. Pinkney, you're here for a warrant. It's a VOP warrant. It looks like you're on probation for 14 charges. They are conspiracy to racketeer. Count 2 is conspiring to racketeer. You have trafficking and stolen property, a second charge of trafficking and stolen property, 2 counts of grand theft, 1 additional count of conspiring to racketeer, 1 additional count of trafficking and stolen goods, grand theft, another count of trafficking and stolen property, another count of trafficking and stolen property, 2 more counts of grand theft, and lastly, conspiring to racketeer. A total of 14 charges. Do you want me to appoint the public defender's office to represent you on these violations of probation?
No, sir, I have representation.
Okay, fair enough. If you change your mind, you can always ask later. I'm looking at a warrant signed by Judge Harb. Judge Harb signed it about 2.5 weeks ago on May the 15th. Ms. Smith, go right ahead with any challenges or any argument for bonds.
He has, he can be violated for this, but he's only violated for not paying money. And I'm not quite sure why this judge keeps holding people no bond on these type of technicalities, but he owes $4,688 in arrears, and then he owes $65 in arrears for something else. And that's the only violations. Back in the day, they used to just do notice to appears on these, and people would just come to court. They'd violate. You can certainly be violated for not paying money, but you're not supposed to be incarcerated for not paying money on a violation probation charge. So I know the court's probably not inclined to ROR him or give him a bond, but I would ask for an earlier court date on that, and he can let his attorney know about the court date. But this is just, in my opinion, this is just wrong. So I would ask for an earlier court date if the court's not inclined to ROR him.
Mr. Matthews, your thoughts? Or anything to add?
I think it's all before the court. It's a no bond warrant. It looks like it was a statewide prosecution case from what I could tell. So I don't have details on the proceedings. But considering the charges, I'm considering the warrant, state's asking this court honor that warrant.
Were you trying to tell me something?
He's got a court date for the 9th.
For the 9th.
Of June?
Yes.
That's a quick turnaround, that's a week from then. So, sir, having found probable cause, because I'm looking at Judge Harb's warrant, he's the one who signed it, finding probable cause. He wanted you to be held no bond, so I'm going to hold you no bond. But after all that, what we just talked about, yeah, you got a quick turnaround. You're going to go see him a week from today. Have a great day, sir.
Are you too?
Colleen Tanner is
Colin
charged
Tanner.
with four. I apologize, sir. Colin.
You're okay.
Colin. I
Yes,
should
sir.
have known that. My apologies. Colin Nathaniel Tanner is charged with disorderly intoxication, possession of an open container, resisting without violence, and trespass. Sir, do you want me to appoint the public defender to represent you?
Yes, sir.
I'll appoint that office to represent you. I've looked over the sheriff's office affidavit. I find probable cause for the charges. Taking a look, you got some prior history. I'm going to set your bond at the standard bonds, $250 for the disorderly intoxication, $250 for the trespass, $250 for the open container, and $1,000 for the resisting without. Have a nice day, sir. And William Morales Torres?
Yes, sir.
Sir, you're charged with unarmed burglary of an occupied dwelling and resisting an officer without violence. Do you want me to appoint the public defender?
Yes, Your Honor.
Okay. He has other charges that are here. Oh, I didn't get that. And I apologize, sir. Apparently after you came through and they made the batting order, and I got the paperwork, another affidavit came through with additional charges, so I'm going to have to read that. Because the one I read just has the burglary and resisting. But it looks like you were charged with, can you pull up that again? You were charged with the burglary and the resisting, and then they've added a domestic battery, a grand theft of a motor vehicle, and a criminal mischief. So there has to be another affidavit. I think pretrial has it for me here. I'm going to take a look at it. This is just a domestic battery, so there's multiple extra affidavits. Got it. Bear with me, sir. I'm going to read this one so I can get caught up.
Yes, sir.
I think we got off pretty light. Went the whole day without it ringing. All right, I read the domestic battery and I find probable cause. Then there's an additional one, so it's got a total of 3 affidavits.
Yes.
2, 1, and 2 to add up for the 5 charges. Now I'm reading the grand theft and the criminal mischief.
Okay, thank you so much.
Looking for the criminal mischief. It was the strap. Broke the strap which held the four-wheeler to the trailer. That's the criminal mischief. All right, sir. I find probable cause for those last 2 charges, the grand theft and the criminal mischief. Going to set your bond on the unarmed burglary of an occupied dwelling. Yeah, this is where he was fleeing from the police and he went underneath the curtilage underneath the house. So we're going to set your bond at the standard bond, $15,000. Going to set your bond on the resisting without at $1,000. Your bond on the domestic battery is $5,000. Your bond on the grand theft motor vehicle is $5,000. And on the criminal mischief, it's $250. All those bonds are going to be conditions of pretrial release. If you're able to post those bonds, you must immediately check in with pretrial services, sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions, plus special conditions 16, 17, 18, and the event location, 21. So you can't have weapons or firearms in your possession. You can't have any intentional contact with the victim. In this case, there's multiple victims. There's the domestic victim, and there's the grand theft victim, and there's the victim of the crawling underneath allegedly the house, the curtilage, while you're fleeing from the police. So you have at least 3 victims there. You have to stay 500 feet away from them, their home, their vehicles, where they work, and where they go to school. On the allegation involving the domestic, since it appears as though you resided with the same victim prior to your arrest, you will get to go back one time within 48 hours of your release, accompanied by the police to retrieve your essential items like medicine and clothing, and of course, stay away from the event location. Have a great day, sir.
All right, thank you, sir.
Yeah. PD appointed. All right.
Your Honor, how much was the bond?
So in all 3 cases, sir, you have the public defender. The bond, I'll do the quick math, $26,250.
So that's
Great.
the total?
Yeah, the big one was the burglary. Essen Zimmerman.
Yes, Your Honor.
Yeah, you were charged with 1, 2, 3, 4, 5, 6 charges, Mr. Zimmerman. They are battery on a police officer, resisting an officer without violence, depriving an officer of means of communication, possession of drug paraphernalia, trafficking in amphetamine greater than 200 grams, and resisting an officer with violence. Sir, do you want me to appoint the public defender to represent you on these 6 charges?
Yes, please.
All right, I'll provisionally appoint that office to represent you. I have reviewed the affidavit from the sheriff back in my office. I do find probable cause for those 6 charges. Do you want to be heard as it relates to bond on the trafficking?
I do, Your Honor, thank you. The state's filing a motion for pretrial detention on that count, providing a hard copy to appointed counsel. May I approach?
Yes, sir.
Respectfully request the court review this motion, and if the court finds it facially sufficient, the accused be held no bond on the trafficking and amphetamine count. So a hearing on this motion, which should be set next Monday at 1 o'clock on the A2 docket. Thank you.
Ms. Smith, anything from you?
No, Your Honor.
All right. Mr. Zimmerman, having found probable cause for all of these charges, going to set your bond at $5,000 on the resisting with violence, $5,000 on the battery on a police officer, $1,000 on the resisting without, $5,000 on the depriving a police officer of his means of communication, $1,000 on the drug paraphernalia, and I am going to find that this motion for pretrial detention is legally and facially sufficient. I'm going to hold you no bond and send you to see the A2 judge a week from yesterday at 1 p.m. Okay. As far as pretrial release conditions, Mr. Matthews, are you requesting that he go on pretrial release?
No, sir.
Okay. Have a great day, sir. Deputies, it is 2:55.
Yes, sir.
I told Davis today that it would be 2 something. I wasn't promising 2:10, and I didn't say it wouldn't be 2:59, but it was going to be 2 something. So.
It is in fact 2 something.
Yeah, there you go. Y'all have a great rest of your day.
Thank you, y'all too.
Help, guys. State didn't ask for him, and he's being held no bond, so no, I did.